in June to mark the many years that he was with our firm. And I practiced with Harry years before that at another firm.
Actually, so did I.
And so did you. That's right. He's been an important person to our lives, and he's a man of integrity, a man of vision. We really enjoyed all the years that we worked with Harry, and he's having a great time in retirement. So today we're going to, the idea is that we're here to answer questions. We're going to start out, you got the agenda there, and those are some of the things we're going to go through. At any point that you want, we want to just keep these things going. Feel free to throw up a question. And then particularly in the second session, we'll take anything on that we know about. And even if we don't know about it, we'll give an opinion.
Or we can get back to you.
Or we can get back to you. That may be the number one thing, because there's a lot of rules. The FCC has a lot of rules, and they have a lot of policies. And sometimes those policies shift around when you least expect it. So there may be things that we say, I don't know that, but I'll get back to you. On the agenda that you've got there, you've got both Kathleen and my email address and our telephone numbers. So feel free at any time to contact us. We're very sensitive to the fact that that you're running ministries and that there's not piles of money, and so we try to take care of you and not cost you a lot of money. And if it's a simple question, you're probably going to find that that's on the cuff. So let's start out. The first thing we're going to talk about, and I believe Kathleen's going to take it, is on this upcoming nationwide EAS test.
Now, I'm assuming that all of you know about the upcoming test, and you all know about the obligation to register each station. That's full power stations and LPFMs and Class A's televisions. You don't have to register translators. You don't have to register boosters. The ETRS system is a new system, so it's a little bit unfamiliar to us on our side, and therefore unfamiliar to you guys, although we're here to help to the extent necessary. You were obligated to have filed or to register and file Form 1 by August 26th. There are a number of people that did not, and we have now started getting notices from the FCC where we are listed as a contact in your overall FCC records. So to the extent that I have gotten a notice on behalf of any of your stations, you should already have heard from me. But if you didn't, you'll probably hear from me Wednesday when I'm back in the office. But the test itself is the 28th of this month. And within 24 hours of the test,
We're actually a little shorter than that, by midnight.
Well, it is, that's true. They originally said you have to do it within a day, but the fact is you have to do it by midnight of the day, I guess, of the test, right. So you have a little less than a day. In any event, you have to file Form 2. Form 2 will only have two questions. Did you receive the test, and did you retransmit it? So it'll be a fairly simple thing, but you do have to log in, and you do have to file that on the first day. Then the Form 3 is due on, it's in the middle of November. I believe it's the 14th of November.
I believe it is the 14th.
Although they haven't officially come out, I think, with the date, but by the 14th. And we don't know the questions that are going to be on the Form 3 specifically, but we understand that it's going to be more detail about what you received, how you received it, whether you received it, and if you did not receive it, why you didn't receive it, and if you did not retransmit it, why you didn't retransmit. For anybody who did not register by the 26th of August, you still have time. You need to have it done by the 26th of September, or you can make modifications to your existing Form 1 and existing registration by the 26th of September. So if you haven't done it and you need help, now is the time, because the FCC is very clearly looking. They are sending notices to lawyers and
to the principals.
Principals.
I mean, whoever's the contact person on your FRN, I believe, as opposed to the facility ID. One of those two. They're doing a sweep. Let me mention one thing. We talked about the translators and FM boosters are exempt. If you have satellite stations, they are also exempt, but those don't come up automatically as exempt, and the FCC staff has been putting notices out to those stations saying, why haven't you registered? And we've simply been writing back and saying, because we're a satellite. A satellite has to be a station that's rebroadcasting 100% of the time a hub station. Now, I don't know if you have any of those, but those are exempt, but you have to let them know they're exempt.
Right.
Okay.
Anyway, I think that's about it, unless anybody has any questions that I can answer on the system as it stands. Bill?
Low power stations don't normally transmit anything relating to EAS. They don't transmit tests.
They have to pass through, they're supposed to be able to pass through a test.
Right.
So they're supposed to be able to retransmit these?
Correct.
Because I don't know about the newer equipment, but originally LPFMs didn't even have encoders. So they couldn't transmit anything.
They're supposed to be able to put in their audio chain if they receive a test. They're supposed to be able to put that test out. They have no obligation to originate tests
Right.
themselves. Okay, but they are supposed to have EAS equipment installed that will allow them to receive a
through.
test and pass it through.
So just to clarify, when you're saying pass through, you mean to broadcast over the air?
Correct.
Right, so not LPFMs, broadcast over the air, not pass on to another station?
I don't know of any LPFM that's a monitoring point for. They
Right.
could be, but I don't know of any that are because of their limited power. So the idea is that it will go out to the public. Now this test will be at 2:20 Eastern Time on the 28th. It should last 30 seconds.
Right. Now,
Yeah.
the FCC has indicated that if for some reason the September 28th test does not come off, there is a backup date of October 10th. I will tell you that I have no idea what would cause the September 28th test not to go off. But they've got
Right.
a backup date.
They've got a backup.
They've got a backup date. I'm sorry?
Correct.
Oh,
I mean,
okay.
I would think if
Yeah.
they would not, if we had,
Yeah.
God forbid, a terrorist attack,
Right.
they very well might choose to not run the national test, because we expect, even though it's a test, we expect people to be alarmed by it. Now, just so it came up with one of my clients, I asked if this is also going to be a test of the alert system that you'd get alerts through your phone, and it's not. This is focusing on EAS only.
Can I ask a question?
Sure.
Who's originating it? Where is it originating from?
Washington, D.C.
Who's originating it?
I believe it's originating from the FCC in Washington.
Right, and
But I
now
don't have
one of the
specific-
things that you've done is that hopefully you've gotten your software patch in, so it has the 6-0 designator code. One of the things they found when they did the 2000, this is more than you want to know about ES, but I'll put it. One of the things they found when they did the 2011 test is the code, the location came up at Washington, D.C., and a lot of equipment said, we don't care about Washington, D.C., so it didn't broadcast it. So they developed basically a national test code, which is 6 zeros. And your equipment, you should have gotten, or if you haven't, you should upload software patches to your EAS equipment to make sure that it will recognize the 6-0 code.
One other factor that I should mention is that if your stations are silent now, you still are obligated to register and file Form 1. And after the test, you will be obligated to go in and file Form 2 and answer the questions negatively. And then in Form 3, you'll be obligated to explain why. But you can, if you are off the air, you still have to register, but you can not receive the test. You're still obligated to register. Yep.
What's the period of time between Form 2 and Form 3?
The Form 2 will be the day of the test by midnight, and then November 14th, I believe, is the day for Form 3. And as I said, we don't know what questions specifically are on Form 3. Rob?
One more question. Is this normally going to receive this daisy chain type of situation, or is it coming in directly? Does that make sense what I'm asking?
It's doing it, it depends on what you're monitoring.
Right.
Because some stations, of course, are receiving the input I can't remember the designation, what are they, LP1s or something? That the designate, they're receiving the designation directly from whatever the authority is, whether that's Homeland Security, the FCC, Office of Emergency Preparedness, and then other people will daisy chain off of that. It
Right.
depends on your state association and what monitoring assignments you have. Now, if you don't know what I'm talking about, you should check with your engineer and get
Rob, did you
Okay.
have another question?
I think that's the answer. I think that's the answer. I was a question of, was this going to be, I haven't even looked at this part, is this going to be a star to all the CAP, in other words, through IPOS, through CAP?
Correct.
Is it going to be, well, no, that's the question. If it's through CAP, then there's no need to monitor a thing, because it's just gonna go straight to the units via the internet. Okay? If it's daisy chain, then it would be a true test of the system. If the CAP entries were going to, let's say, just the state relays or the entry.
I think it's both.
Right, it's
I really
supposed to
believe
be a
it's both.
test of the entire system.
Right.
Make sure it doesn't wreck itself. Okay.
Right.
Correct.
So you might see duplication come through is what, yeah, that's my.
It's possible, yes, that it's possible.
So if that's true, then which one are we supposed to relay?
The one you get at 2:20 in the afternoon or Eastern time, man.
I think it's the one you get first.
I would say my reaction would be the first one that you get is what you relay.
So if that happens to be the iPod,
Then, exactly,
one, if it's LP1, it doesn't matter.
Correct.
yep,
But you don't have to do it twice. Whatever, you only have to do it once.
right.
The encoder index should probably determine which one. and
Yeah.
one of the other two, right? Yeah.
Correct.
So basically, whatever the first message we get is what we send out, and then on Form 3, we indicate which one we sent out.
Correct. We don't know what the
We
Form
don't know
3
what Form
questions
3
is. Yeah.
But if the question is on Form, my belief is the question will be on Form 3, but I don't know that.
In a successful test too, you wanna make sure that your equipment's on automatic mode, like those
Right.
Sage, because you can put it on a non-automatic mode where if the red light's flashing on the front, it won't automatically forward. And if it's not flashing on the front and it's not in automatic mode, then you have to manually forward the test within a certain period of time. So if automatic is the best way to go. What's that?
And do automatic.
And do automatic, but make sure, because I've seen Sage's power cycle, in maybe an older version of firmware, and not come back as automatic before. So make sure that the red light that says automatic on your Sage is on.
One other thing that the FCC staff has indicated is if you do not have equipment that is the newest and newest available, you still have to register, you still have to file Form 1, and they still expect you to participate in the test to the extent that your equipment works. You will be given the opportunity, obviously, in Form 2 to say, no, you didn't pass it on, or you didn't receive it, and in Form 3 you will end up having to indicate why. And you will have the opportunity to say that your equipment wasn't functioning properly. That said, the FCC is hoping that everybody, to the extent possible, will have the newest equipment and the newest software in place in time for the test. But I think they acknowledge that when they started making the announcements, even though it's been several months, that a number of stations have gone out to the manufacturers to try and order and get in place updated equipment, and the manufacturers are jammed. So not everybody is going to have their equipment and have it in place in time.
So why don't we move on, unless there's other questions on EAS, we'll move on to our next topic, which is the new online public inspection file system. So first of all, you LPFM folks, you can just take a nap because you don't have a public inspection file. You don't have to worry about it. Everybody else, you're going to be looking at needing to to move to the online public inspection file by the March 1 of 2018. And what that's going to mean is that the FCC it's established a system, a server, a system, we'll leave it at that, where the public can look up your public inspection file. Now, what you've got a responsibility for, well, you're responsible for the file generally, but what you've got a primary responsibility for is to upload to that file the items that are not filed with the FCC. Everything that's filed with the FCC will go to your file automatically.
Can I
If that's
clarify?
yeah.
Anything that's filed electronically
I mean, you're right.
with the FCC.
Yes.
If you file
if
it on
anybody-
paper, you have to upload it.
If anybody has an AM, one of the few things that are not electronically filed now is an AM license application. So you would, if you have an AM station and you were up filing a license application, whether that was for modified facilities, a new facility, or a direct measurement of power, you would have to upload that on your own. You could, if you wanted to, transition to the online public inspection file now and relieve yourself of maintaining your local public inspection file with a couple of caveats. You will still need to keep locally letters from the public. It's not going to probably be a factor with you guys, but you do have to keep your political file for the past 2 years locally. That's the retention time for the political file. Once you make the transition to your online public inspection file, and again, the deadline for doing that is March 1 of 2018. Once you do that, then your political file going forward will need to be online. Now, like I say, I don't imagine you're going to have a lot of things in your political file. You're not, if you're non-commercial, you're not allowed to sell time. You are required to make note of if you give time away to candidates. I'm finding some clients of ours that are not, let me mention that stations that are commercial in the top 50 markets and have 5 or more full-time employees are already required to go to have an online public inspection file presence. And we can thank them for leading the way and finding all the bugs that there are in the system. And there have been substantial bugs. I mean, there have been problems with that. So by the time you guys come along, it should be fairly easy. The main things that you're going to need to upload to the public inspection file will be your quarterly issues programs list. And if anybody here glazes over and says, "What's that?" we need to talk. Because it's going to be something that the FCC has been focusing on, and once we go to an online public inspection file, they're going to be focusing on even more. We found that in the last television renewals, now television, by the way, has had online public inspection file for what?
3 years?
Three years or so, and we found that the FCC has gone in and reviewed those files on its own when we've come up for renewal. And if we've answered a question wrong in the renewal application, there's been adverse consequences, including monetary forfeitures. If someone says, "No, our public inspection file is complete," and they come back and they say, "You're missing 16 quarterly issues programs lists, and here's your fine, and fix it." So we're anticipating that same type of scrutiny will come up in the next renewal cycle for radio.
Couple other points. Remember that with many things that you have to file in the public file, there's a timing requirement. And because this is electronic, the FCC can tell exactly when you uploaded it. And in the renewal cycle for television, where this was a first-time, very real issue, the FCC came back and said, "You didn't file that on time." And if you indicate in your renewal application that you timely filed, which is part of the question, did you file and did you file timely? You can't answer that question yes. You have to give an exhibit explaining why. Now, I actually had a situation, and I'll get to you, Rob. I had a situation with a Class A television in California, and he filed his children's reports by midnight, California time. California time. Showed late, 3 hours late. And we had probably 6 quarters that I had to explain to the FCC that he actually filed it timely. He filed it timely midnight his time. He didn't file it East Coast time. And ultimately, he was not fined, but that I believe, honestly, in the next renewal cycle, there won't be any leeway for that. I don't think there will be any leeway for it. So you do have to keep that in mind. And I was going to make one other point, and I've lost it.
Okay. One of the other things that it'll come to you.
It will.
One of the other things that you will, besides your quarterly issues programs list, if any of you have 5 or more full-time employees, then you, for the radio station, not necessarily for your church, but for the radio station, you have to prepare an annual EEO public file report. And that is also something that will need to be uploaded to your online public inspection file. Now, let me mention one other thing about online public inspection file is that if you have a website, you will need to have a link to the FCC's online public inspection file on your, I believe it has to be on your front page, and it has to be obvious. So,
They're regulating websites now.
well, they're telling you where to put things, and they are, in fact, in some ways they are regulated, because for those people that have the requirement of EEO public file reports, they've had to post those on their website as well. And we've gotten calls saying, we can't find it, and we point out where it is, and then they have a mild suggestion that we might want to make it a little more obvious where they are. In the online public inspection file, I believe it's very explicit. It has to be on your front page.
Right. Now, and Rob, let me say this just before I forget it again. The comment that I was going to make is that during the television renewal cycle, we not only got calls from the FCC staff saying you didn't file on time, but they came back to us on issues programs list and said, we don't like the way you did this. You have to redo these.
Right.
And although they didn't make you go back the full license term, so they didn't make you go back 8 years, they did in a couple of instances make me, or make my clients, as the case may be, go back 2 years and correct the format of the issues programs list. And there's not, bear in mind, the FCC doesn't have a designated format. They do have, the rules do indicate what you have to have in the issues programs list itself. So if you follow the rule, then technically you should be okay, even if it's in a format that the FCC doesn't like. But that doesn't stop them from coming back and saying, you have to modify these.
Right.
I mean,
So is there a sample format that you have recognized?
Send us an email,
Yeah,
and we'll
and
send you
we'll send you one.
our sample format.
Yep.
Fundamentally, you identify issues, and how you have wide latitude in determining what those issues are as a licensee.
Our local broadcast association came out and did a mock inspection for us. And
Right.
They gave us a bunch of forms
Right.
that we used to fill out our public.
you're probably
They're-
fine
you're
there.
probably gonna be
You're
fine
probably
right
fine
there.
Now, Rob, I know you had a question.
Okay.
This is about the issues programs list and sort of liability. There are two people that I'm aware of in this room who lease HD channels that others are the licensee of. Okay, 100% of the programming that is on those HD channels, for which a published file is, I believe, supposed to be kept. Right? Okay.
It's up to the licensee.
Yeah.
It's a
licensee.
But could there be an issue of the licensee coming back to the person running that HD channel saying, your public affairs programming for this community is licensed, that we're on the HD channel?
You go. You start.
My initial thought is it's a contract question.
Right.
So that in your agreement to be the programmer of an HD channel, presumably, it's very much the same as an LMA. You would have language in there requiring the programmer to provide information to the licensee for their use in preparing the issues programs.
Okay, just a second then. Jim, Scott, and Rob, has any of you ever communicated about the programming that you air to the licensee? Every time I have any communication with them, it's when they have an ice storm and the HD is off. Right. The point is that would this become an issue later?
In my Baltimore arrangement, at 6 o'clock on Sunday morning, CBS overrides my programming for an hour.
So you have that.
And they air their public affairs program.
But you still need documentation is what you're talking about. The issue is, so if we sent it to, in our case, it's Cumulus, we just sent it up to them and said, put this in your public file, we're good.
I wouldn't even say put this in your public file.
I would
Say,
send it to them
Here's,
because they're the
here's the
licensee."
stuff, you can use it. Let me just, it's not at all clear that a separate issues programs list has to be done for an HD stream. So it's not at all clear. If we follow basically the model, the issues programs list does not have to be comprehensive. It's not a log. The licensee chooses what is the programming that it believes, I can't remember the word, but basically best addresses the issues that the licensee has identified. And therefore, it could arguably say, well, none of the programming on the HD4 is what we're relying on. We're relying on this programming here. So I don't think you've got a liability to the licensee unless it's contractual in your contract. And if it's in your contract, if you've got an LMA, then as to reiterate what we just said, I think the best thing to do is take your public affairs programming sheets and information and send it on to the licensee and say, by the way, this is the public affairs programming that we aired. And then they can choose whether they include it in their public inspection file or not. Okay.
Bill?
Forgive me if this has already been answered, but are LPFMs required to do all this?
No.
No.
No, that's why we told the LPFMs they can just take a nap. You know, that's right. LPFMs have no public inspection file requirements. They have some logging requirements, as I recall, but not a.
Renewal time, can I tell the FCC I was confused and thought I had an LPFM station?
I wouldn't
No.
recommend that.
No.
No.
The answer, no.
No, yeah, I think maybe
The
Kathleen's
answer
right.
is
No.
no.
In the interest of covering our list,
Oh,
Yeah,
okay.
okay.
10:15, we'll have time for questions in the second session.
All right.
Okay, so the next thing we're going to talk about, and we'll do this fairly quickly, I think, is
covering it.
document retention requirements, both in the existing paper public file and in the new online public file. The retention obligations don't change in the new online public file, bearing in mind, of course, that now with electronic filings, you're not going to be uploading some of that, but you will be able to remove items that are no longer required to be in the public file. So once, even FCC filings, there's a little way there's an X and you can actually remove it from the file. Be careful not to remove things that are required to be there. That's fairly simple. Obviously, after your renewal, you want to go through and start removing things that aren't required there anymore. We talked about the fact that you will need to continue to retain a paper public file at your studios with communications from the public. There is pending a rulemaking petition I think it's a rulemaking petition.
Correct.
In any event, to have the obligation to retain the communications file moved to the online file. That's pending. I don't know that we'll see anything happen really, really quickly, although you may have more intel on it.
And the second question of that is to do away with it altogether.
Right.
So there's a possibility, and I actually think that the trend will be
think it will.
that they're just going to say, you don't have to keep records of communications you get from the public. It's not on a fast track, but it's on
But
a
there has been
faster
some
track
trade
than
press.
some of the things
Yeah.
we're going to talk about
There
later.
has been some trade press. Okay, so Matt indicated earlier that political files, you have to
Right.
maintain them for 2 years. Your annual ownership reports, you have to keep the existing ownership report there until you file your next full ownership report. If you file an ownership report that essentially certifies that no changes have been made, then you need to keep that one, as well as the last full ownership report there, so somebody has the ability to go in and see your ownership structure. What else?
At the end of, after your renewal, we're covering the same thing. After your license has been renewed, you can pull down all the previous terms, quarterly issues, programs lists, and frankly, we recommend it. Something else, with applications, people are usually going to leave their construction permit applications up. You don't need to. You don't even need to, unless you had a waiver request. If you put a construction permit application in and it had a waiver request, you have to keep that application on file in the public inspection file until the waiver's no longer applicable. The same with any other application. Once granted the application is final, you can pull it down. Okay, so if you have doubt, basically if you have doubt, leave it up. Or if you have doubt, give one of us a call and we can tell you quickly.
The logs, you're still not talking low power?
Not for public files.
Not for public files.
Not for
Logs,
public files. Logs are
there's a
different issue.
specific rule for LPFM logs that I don't know off the top of my head. Generally speaking, logs are required to be kept for 2 years.
Right.
And that's certainly for the full power folks. You've got to keep your logs for 2 years. Those logs will show when you ran EAS tests, when you did light inspections. They're supposed to reflect other things that you've done, and which I can't recall right off the top of my head. I think it's section 73-1820, but don't hold me to that.
so
Okay,
let's-
where are we going next?
Main studios,
Main
staffing
studios.
requirements.
LPFM people, continue your nap. Sorta. If you made a pledge in your application, and that that you were going to maintain a main studio for a certain number of hours per week, or you were going to originate programming a certain number of hours per week, you're bound by that pledge. If you didn't make it, you don't have a main studio requirement. Let's talk about your full power people. You are under the same rules if you're the originating station as a commercial station. You're the same, as Cumulus's Nash FM. You've got a requirement to have a main studio.
In
and
your
that
city
means-
of license,
In your-
within 25 miles of the coordinates of your city of license, or within the primary service contour of any AM, FM, or television licensed to the same city of license. I remembered them.
And it's got to, yeah, and it's got to be, bizarrely enough, both Kathleen and I have been at this long enough. We remember when you actually had to originate programming from your main studio. And in fact, you had to originate at least 50% of your programming from your main studio. You don't have to originate 1 second of programming from your main studio, but you have to have the ability to do so. And there have been some cases, some letter rulings that they said, that's a little thin, or well, it said that you can't do it. But the requirement is that you do have a main studio, that you have a full-time presence there. And there's a case called Jones Eastern where the standard was laid out, including the phrase, which we'll get to, chained to the desk. You're required to have someone present at the main studio during normal business hours. What's normal business hours? The only actual place where it shows up is that there's in some of the commission worksheets, and I believe in the inspection checklist, they basically say, and Rob, you can correct me, 8 hour period between 8 and 6 is what's normal business hours. Additionally, there has to be a manager who calls the main studio his or her main office and spends a substantial amount of time there, but does not need to be, quote, chained to the desk.
It does mean, however, that you have to have someone in the studio at all times during the 8 hour period between 8 and 6. You don't have to be chained there, but you have to have one person there.
Right.
Sorry.
That studio location, because most of us, the church office and the studio are co-located.
Right.
Okay, so that could be like the church secretary.
If
Sure.
Yes, it can.
Second thing, so 8 hour period, is that synonymous with 40 hours a week or 5 days a week?
The reason is
5 days a week. You don't have to worry about the weekend.
okay, and it does have to be 5. The reason is our church offices are open for Monday through Thursday. Do we have to have somebody in the building then for the radio station on that day that nothing else is open?
Correct. Unless you want to gamble. Right.
Exactly.
Which is, I'm not saying it's a safe gamble, but it's not unheard of. Usually the FCC, what happens is the FCC comes by, they've got the main studio address, which they may have it right and they may have it wrong, and they come by and they come on knock at the door and nobody answers, and they make a notation of that, and then they come back, usually the next day, but not always. Sometimes they come back about an hour later and find them that no one's there, and then the next thing you do is you get a notice of apparent liability that you did not have properly maintain your main studio. And, you don't want to mess with that if you can
So
avoid it.
if the church office is closed, but we have somebody manning the studio, and we have a way for the FCC inspector to contact that person, they cannot let them in, that's valid?
That's fine,
Yes.
fine.
In other words, sign on the door that
Sign on
says
the door.
access to the radio station called such and such.
Yes.
Assuming that person's in that building.
Right.
Right, that they come and lock the door. I will say, you got to be responsive, because we've had some cases, especially in LPTV, where people have said, I'm not going to let you in, wrong answer.
Wrong answer.
Or we actually had one that said, I'm terribly sick and I've got to leave for the doctor, and the FCC didn't accept it. You know,
$80,000 fine.
$8,000 fine, and
What about, I'm on lunch right now?
No, that's, technically, you have to have somebody there during that 8-hour period. Technically, you're
doesn't
not
have to be the
I mean,
same person.
No, as long as someone is there. Even technically, I mean, if you're worried about having somebody there and one of the employees of the station needs to be away, you can have somebody else from the church there. As long as there's somebody there that can open the door and show the FCC the public file, at least for right now, then technically you're okay. You can say the person who's normally here is away at lunch, they'll be back in an hour, but let me show you. And then I think you're probably fine.
Look,
What she was saying is making sure that whoever is there, like if it's a secretary in another part of the building, is aware that the radio station exists, that would be helpful.
we've had problems with that at times.
Right, absolutely. I mean, you're told that you can use a secretary for it, and the secretary says, well, somebody walks in, and this happens, because I've had it happen, not during an inspection, but to me, where I say the secretary, and that's the only person, I say, well, where's the station? She's like, I don't know anything about that, that's there. You know, just, that's not what you want to say to the FCC.
I've actually gone into a station and asked to see their public file and have the person at the front desk say to me, huh? Deer in headlights? No idea.
Your manager's office, where the manager's away and it's inaccessible.
Correct. Let me get to your, go ahead, Rob.
Just a quick question. For clarification, is it for public file accessibility? This is not for control point. What is it?
This is the public, where the public file is located.
Main studio. What about control point? In other words, I access to turn off the transmitter. If they come in and say, can you turn off the transmitter as a chief operator that's designated here? Does that all fall into the same thing, or are we talking just for
Those are different, we're only talking
Different
public
rules.
inspection file.
Right.
It used to be, there was folklore, and I don't think it's still the case, that it used to be that the inspector would come in and say, and tell someone that they have to do an EAS test. And I have not heard of any
haven't heard of
occasion
anybody.
in the last 10 years where an inspector has done that. And one of the things that's happened, and I'll mention this to you as well, and maybe Rob's already counted, we've had, first of all, because the Enforcement Bureau has been, the field offices have been stripped down, many of the offices have been closed, there's far fewer inspections than there used to be. Usually when there's an inspection, it's related to a complaint having been filed. I used to think it was related to whether the inspector was going fishing down on the coast by your station, but they tell me that's not true anymore. But if you can have a mock inspection, it's a good thing to do. Through the State Broadcasters Association, because you get an exemption for a period of time from random inspections. You're not exempt from an inspection based on a complaint. You're not exempt from an inspection that's based on an overall commission compliance program. They had one a few years ago for television stations about compliance for political files. So
We should probably move
we
on.
should move on since we've used up most of the hour and we're okay. We're talking about music licensing.
Let's go to 10:15.
Okay, sounds great. Music licensing. The question kind of I focused on is, can you use, you've got an ASCAP, you've got a BMI, and you've got a CSAC license. Can we take the record off the shelf or I aged myself again. Can I go to my hard drive and pull up some of my music and use it in a commercial? And the bottom line is no, or in an underwriting spot, because you haven't secured all of the rights. It's not so much your ASCAP, BMI, and CSAC licenses. You haven't secured all the rights to make a copy of that music for the purposes of other than playing it over the air. The long and the short of it. Interstitial music, bumps. Yeah, you can use that for bumps. Can you use it for promos? It's a little, for a non-commercial station, the recommendation I've got to give you is no. Because these music licensing companies, not so much the ASCAP, BMI, and CSAC, but the people that are the publishers of the music and the owners of the copyrights of the sound recordings protect that very closely. And if it's just really important to you to use a particular piece of music on on an underwriting spot or a commercial or a promo, then you've got to go to the owners of those copyrights. Typically, the record company owns the sound recording. Typically, some publisher, it could be the actual musicians or the person who wrote the song, owns the copyright to the underlying music. And you got to go to them and get their permission. Sometimes that permission will be wonderful. I really think Calvary Chapel's doing a wonderful job. You can do it for free. Other times it'd be, my daughter works for Hilton Hotel, and they recently, in the corporate offices, and they recently had a commercial that featured, I think, Satisfaction from the Rolling Stone. They paid a little bit of money to use that in that commercial. A little bit of money. So that's one of the answers. Let me know what other music licensing. Go ahead.
This may be a silly question.
There's no such thing. All right. There are silly questions. But go.
Why then do so many music services include the instrumental track along with the radio track?
Technically, they're two different pieces of music, and they're different copyright. They're
Right.
different copyright coverages. You can have the music just alone, and there's one copyright coverage there, and then you have music and words, and that's at separate copyrights. If you have both, they want to make sure that you're covered, that you're licensed to use both. That's really what it comes down to.
Go ahead. Yes.
When we have a worship leader and just wanted to revive one song from another artist and play it on the radio station, non-commercial.
Well, you've got it covered. You've got it covered with your ASCAP, BMI, and CSAP. Presumably, they're signed up with one of those agencies, and so if you have your regular music license, you can play anything on the air. If you're signed up with ASCAP, BMI, and CSAC, all three, you can play anything in their repertoire as part of your regular music programming. Now, some of you may have per programming licenses, and we won't get into the weeds on that because we don't have much time.
We had a question
But we'll
over
be
here.
happy to talk about it later.
Correct me if I'm wrong, but Joey, the reason that the instrumental tracks are provided with the regular track is actually for live performance. That's why those instrumental tracks are provided. They're not provided for promo creation.
Oh, okay.
Okay.
Good.
It's if you only have a guitar player and singing, and you want to have that full sound of Elevation Worship or Hillsong, you'll have the track to play with. It's only for live performance use.
Okay.
Why don't we move on?
We're
Next
moving
is,
on.
biennial.
Biennial ownership reports.
Can I start that one?
You start that.
Right now, as the rules are changing, but they haven't gone into effect yet. Right now, you're obligated to file an annual ownership or biennial ownership report on the month in which your station would file its renewal.
No.
LPFMs can stay asleep.
Continue your nap. Yeah,
Yep.
that's right.
It will wake you up. Anyway, right now you file on the month that you would file your renewal in. That's changing. As with commercial stations, you will ultimately file once, on 1 month, and everybody will file in the same month. With commercial radio and television, they file in November, and it almost always gets extended to December.
Actually, they officially moved it to December.
Oh, did they? Good. Okay. Now the rule changing has to get published in the Federal Register, and once it becomes effective, then we won't have to file on the month that you would have been obligated to file on. We anticipate that we know that the filing obligation will change in 2017, but the new rule hasn't been published in the Federal Register, so we have to keep filing the monthly filings to the extent that they're applicable. I know Missouri and Iowa are due October 1. That's not necessarily exhaustive. I just
No.
know because I've got Iowa and Missouri
So-
stations that I'm working on.
And there's a sequence, like these renewal sequences. Now,
Right.
just so we mentioned renewal, and I'll just touch on it in a second. The renewal cycle will begin again, I believe, in 2019. And the way the renewals work, we'll get back to ownership. Renewals work is sections of the country. We do a certain number of states. They have a renewal due on a particular date, and then we move over to another section of the country, and they have renewals due on it, and it cycles through, And basically, television follows 1 year behind. So if Maryland radio is due, and don't hold me to this date because I don't have that, is due April 1 of 2019, Maryland TV would be due a year later. And then we'll go through that. It takes about 3 years to go through the whole cycle. And at the end of it, then we're good for another 8 years unless Congress changes how long the renewals are. But let's go back to the ownership reports. One of the things that will be coming up, and this is going to be, frankly, a burden, unless one of the petitions for reconsideration or applications for review or pending are granted, and we don't expect them to be, you're going to need to get an FRN for each officer and member of your governing board. And to get that FRN, you're going to have to take that person's Social Security number. Well, there's two ways to do it. You take their full Social Security number, and you register with the FCC, and you get an FRN. And now, if you don't want to do that, you can get what's called a special use FRN, in which you don't register the full Social Security number, you register the last 4 digits, but then you have to provide additional information regarding the person, such as their address. I can't remember what else besides their address.
Telephone number.
Telephone number. I believe there's a telephone number that you have to provide. So they want to be able to know who they're talking about. Now, is this a hassle? Is this, some people say, unnecessary? Absolutely. But there's been a long fight at the FCC, and those of us, including us, lost. We said you shouldn't have to do this, but unfortunately you're going to have to do it. You're going to have to go to your board members and get their Social Security numbers, or at least their last 4 digits of their Social Security number, and get them a personal FRN. Now, if you're in charge of that, make sure you hang on to those and hang on to their passwords. Go ahead.
What prompted this? What's behind this?
The whole reason for all of it is for the FCC to establish a baseline as to the minority and female ownership of broadcast stations. And probably the ultimate objective of that is to see if there would be a constitutionally sustainable program that could be adopted that would give some sort of advantage to minorities and females. Whether they're ever going to satisfy the Supreme Court standard under Adirond, it remains to be seen, but the FCC has gone through this tortuous exercise to get us to that point.
Is there a drop dead date for this to be done?
When the ownership report is due. Okay, now, if you have a person that says, I'm not giving you your Social Security, my Social Security number, I'm just not doing it, and you tell them that, you're required, you are required, the individual required by FCC law to do so, and they still say, I don't care, then you can get what's called a restricted use FRN, which you just grab and you put in. You just basically...
One time.
One time. But the FCC has made it clear that potentially the licensee, if it hasn't gone through all the efforts to try and get it, might be liable. And then more specifically, if the licensee has gone through the efforts to get the Social Security number and thus the FRN, that the individual could have liability, the commission, for violating its rules. So now we can show you how to do it. Sometimes some people are undoubtedly going to have their lawyers do it. There's really not a need to do that. We can show you fairly quickly how to register for to get these FRNs, and it limits the amount of public exposure to that information. Go ahead.
Does all this information include LP?
LPFM? Yeah. LPFMs are not required to file ownership reports, so they don't need to worry about it yet. Go ahead.
LPFM, any requirements for yearly board meetings?
Not from the FCC.
No, that
That may be a state requirement.
State corporate requirement.
Right.
Translator's not required for this.
No, if the licensee only owns a translator, they are not required to file an ownership report. If they're an LPTV, does anybody have TV in here? Then we'll forget about it.
Stop talking
Then
about
forget about it.
We'll stop talking about LP.
Okay, so where are we?
We were there. So
7.
that's
Power increase. Well, I wrote Peter Doyle, the chairman of the, not chairman, He'd like to be chairman.
Yeah,
Let me put it. Maybe who knows? The chief of the audio division, and I said, Peter, I'm going to be talking to the Calvary Radio Conference. They're interested on where we are with the petition for rulemaking that was filed by Rec Networks. And his response back to me was, I have nothing to share with you. Which was, I thought, that doesn't mean there's nothing happening, but he's not going to share with us. But then he went on to explain what their priorities are. Their priorities are to clear up the rest of the LPFM. Well, yeah, yes, that may be true. They're trying to clear up the backlog of the few remaining LPFM cases to be cited. There's very few of those, and the applications for review and the petitions for reconsideration of those. The clear, what I read between the lines is, don't hold your breath. Because there are significant, Rec Networks came out with this. There were more than 500 comments filed, including 77, and this is just at the initial stage. We're not even, this was just, Rec put out the proposal, and we got 500 comments, including 77 comments that were what we would call formal, including the substantive formal comments, not just people saying, yeah, that sounds like a good idea. The proposal has significant opponents, including the National Association. But actually, the NAB is not so much, no, it's not now. Let's finish with what we're doing now, but not now. We're going to put, so, and let me go back to the beginning. The proposal was to increase power for LPFMs up to 250 watts. There were other comments that came along that was talking about more power than that. Bottom line is, it's going to be a while, and it's far from a certainty. At this stage, it's just a proposal, a petition for rulemaking. If the commission chooses to, and it's really within their discretion, the next step would be to issue a notice of proposed rulemaking, and that would invite more comments to come in. And then after all those comments would come in, the commission would have, at its discretion, the power to issue a report and order adopting or not adopting rule changes. Many a notice of proposed rulemaking is never acted on, and just dies. Indeed, we were talking about ownership reports. There's a 1979 notice of inquiry about how we're supposed to report changes in the boards of non-commercial educational licensees that's never been acted upon. And it's still out there, although the commission still cites it against us occasionally. So.
Okay, we're going to move on to the FM translator windows and the AM revitalization order. I'm pretty sure most of you are very familiar with that. The FCC adopted an order to try and assist AM stations by giving them an opportunity to get an FM signal to expand or fill in their existing signal. The FCC opened 2 windows. The first one was end of February? Right. End of February, and that went for several months, and then they opened a second window in the end of July, and that one is still open, in which an AM station could file for, and these had to be non-reserved channels, they could file to move an existing FM station that was existing, meaning there was an existing construction permit or a licensed facility, but they could move it up to 250 miles in order to use it as a fill-in for their existing AM station. I don't have the exact number that was filed in either of those windows, but hundreds and hundreds of FM translator applications were filed, and many of them have been granted. Now we're starting to see some of the fallout of that, where other primary stations are encountering interference from some of these new FM translators that questionably should have been granted to begin with, but that's a whole other issue that we could talk about for a very long time, but we'll let Rob do that. More importantly is there will be 2 more windows that the first of which will probably happen in 2017, but we don't know exactly when, and that will be, the first window will be for Class C and Class D AM stations that did not file in either of the other two windows. They must be for non-reserved channels, and it is not likely to occur, the window won't open until the FCC has finalized the broadcast television spectrum auction. Now, we're in stage 2 of the broadcast spectrum auction. We're in the reverse portion of stage 2, and then the forward portion will go back. The word on the street suggests that there will be at least 3 stages and probably 4. The first stage took about 3 weeks on the reverse side, the broadcast side, and then another several weeks on the forward side before the first stage failed. We're now in the, as I said, the reverse portion of stage 2, and we have to move to the forward portion, and it's anticipated that that will fail. So we don't know exactly how long it's going to take, but we have been advised by the FCC staff that the next AM revitalization window won't open until the spectrum auction is completed.
So, do any of you have AMs? No AMs.
Okay.
Well, then AM revitalization is not
That's
that
enough.
important.
That's enough. I'll stop talking.
They could have CPs that you want to sell.
Correct.
Yeah, they could have CPs, or if I mention this, the reason this might be relevant to some of you is, if you have low power FM stations, the one thing I can guarantee you wanting to know is, how can I get further than I'm going right now on a signal? And a way for you to get further with a signal, if you have the resources, is to buy an AM station that's taking advantage of this revitalization window, and now has a translator that probably covers a good portion of your market, far better than your LPFM does.
Right, because translators, assuming that they're not restricted by other translators, can operate up to 250 watts, and there's no limit on how high they are if they've got a clean channel. For instance, I've got a client that has an LP or a translator in the Kansas City market that's at 1,000 feet at 250 watts. It's like a Class A station. I mean, it's got a real hunk there. Go ahead.
Are either of these two situations legal? An LP either leasing or rebroadcasting on an AM's translator that they own?
Okay, the AM translator, we'll stick with an AM station that has a translator. They are required to rebroadcast the AM station. That's all they can, especially if they
got
if they got it through one of these windows. They're required to rebroadcast that AM station
for 4 years
for
after
4
they
years.
go on the air.
And they may have also, there have been other ways prior to that through something called a Mattoon waiver, where they would also be obligated to only broadcast the AM station. But the FM translator, okay, for LPFMs, we're talking about LPFMs. Okay, LPFMs have a rule that allows them to have up to 2 translators. And those translators have to have, and I'm doing this off the top of my head, which is always a dangerous thing. They have to have an overlap of the translator's 60 dBu with the LPFM 60 dBu. And then there's also, as I recall, a mileage limitation that I think you're limited to 20 kilometers outside the top 50.
That's ownership, not leasing. If you were to use a translator from someone, you're not subject to those.
I wouldn't say that, no, because an LPFM, we could, let me put it this way. If you were going to do that, you should definitely discuss it, because in fact, there is with your counsel, whoever that counsel is, you should definitely discuss it, because there is a significant disagreement with exactly the point that Rob brought as to whether or not you can LMA a translator that you could not own. There's some significant now. Let me say this: that if someone out, I'll get right to you. Oh,
Clarify LMA.
Oh,
Local
LMA
marketing
means local marketing agreement. It can mean a lot of things. Sometimes in non-commercial, it's called a programming agreement. It basically means that an entity is using all of the airtime of a station that's owned by someone else. And there's a whole body of law about what needs to be included in the agreement for that arrangement. Okay.
And there are substantial restrictions when it comes to non-commercial. I mean, you know, you're not,
Right.
you're
Yeah,
not, you're not
particularly.
buying time, so you have to be careful about how
Right.
funds flow and.
Right, there was a
whole
case
structure of
involving the University of San Francisco where if we're talking again, time brokerage agreements and LMAs, TBAs and LMAs are the same thing, just two different names for it. There's no distinction. But there's a lot of, before you enter into, on either side of an LMA, you need to talk to counsel. I mean, there's a lot of things you can do on your own. This is one you really need to talk to a lawyer, because there's a lot of rough edges to what a non-commercial station can do in the way of a TBA. And there's ways that with
Some guidance.
guidance, you can avoid those rough edges. Okay. So we've got 13 after. So we're going to break now, and then we'll come back in 5 minutes for and I
anybody who
think
wants
I
to
may
sit in on
want to
our-
get off of this stage and these lights, and we'll answer any questions you have. Okay. Thank you.